Hello, good afternoon. Welcome to our webinar hosted by the Russo blog group. I
think that we lost Julie. I apologize for that. Lost Ashley. So hold on one second while you're all logging in, and let's see if she can get back on. Otherwise, I'll take over. Oh, here she comes.
Hi, everybody. Sorry, your hostess got booted off the webinar. So I'm not sure if we got too far, but I'm going to go ahead and share the PowerPoints and we will kick it back off. Would not be a live webinar without some kind of issue. So I will start this over. Welcome to our webinar hosted by the Russo Law Group. This presentation is: what is the difference between a healthcare proxy and living will? Do I need both? Today is August the 26th, 2021. Thank you all for joining us. My name is Ashley, and before we begin, let's cover a few housekeeping items. To help minimize any audio distractions, your microphones are muted. Please submit questions through the Q&A window provided on your Zoom toolbar. We might hit on your question during the presentation, but if not, we will circle back around. We've saved time at the end for Q&A. We should be together today for about 45 minutes, but no longer than 1 hour. We created a PowerPoint for the program, which should be showing on your screen along with our webcams. We are recording this and we'll email you today's video. Please complete the webinar survey and leave us your feedback about our program. The survey will show on your browser when the webinar ends. So if anyone has questions about the housekeeping, send me a message in the chat window. Okay, so let's get to know our presenters, and we will start with Deanna Eble. Deanna is a partner at the Russo Law Group. She has 20 very young years experience focusing on elder law, estate planning, special needs, and Medicaid planning. She is the lead planner in our Islandia office. She also meets with clients in Garden City, as well as virtual consultations. Deanna is currently appointed to the executive committee of the New York State Bar Association. Tommaso Marasco, also known as Tommy, is an associate and the newest member to join Team Russo. Before joining the firm, Tommy ran a solo practice in estate planning and real estate. His practice areas also include guardianship, trust and estate, probate, small business planning, and business succession planning. Lastly, Tommy is active in the community and serves in several nonprofit organizations. All right, so now we're going to turn off our webcams, and I'm going to hand it over to Deanna to walk us through today's agenda.
Okay, so I hope everybody's in a nice air-conditioned room and not dealing with this heat while you're listening into us, and that's great. What we're going to cover today is what is a healthcare proxy and a living will, who makes decisions if no advanced healthcare directives are in place, and how can you protect yourself? So, just as a background, the must-have legal documents that we always recommend are a durable power of attorney, the healthcare directives, which are healthcare proxy, living will, medical authorization, and a last will and testament or a living trust. The durable power of attorney is a financial document which we've had some conversations. So if you wanted to go back and look at a previous webinar that we've got on our website and recorded for future reference, you're welcome to go and do that. We also do have some extensive webinars on our website that go into detail about things like wills and living trusts and what different types of living trusts are out there. But today, Tommy and I are going to focus specifically on your healthcare directives, and that being your healthcare proxy, your living will, and medical authorizations like a HIPAA form. So Tommy, tell us, what is a healthcare proxy?
Thank you, Deanna. So a healthcare proxy is an instrument that allows you to designate an agent to make medical decisions on your behalf. This particular instrument does go into some specificity as to what it pertains to. And as I said, it allows you to appoint an agent, and it also allows you to appoint a successor agent or an alternate in the event that primary agent is unable to serve. It also speaks to certain specific situations, such as whether or not it's effective, whether you have capacity or not, whether it is that you wish to have an organ donation, and as to what specifics, and also the topic of artificial nutrition and hydration. So as Deanna had mentioned, with the power of attorney being able to make financial decisions, this document is what allows you to make medical and health decisions. And I think we can all understand with how the last year and a half has played out that the one certainty is that nothing is certain. And so it's very important that we do take control of those things that are within our control today. And having a document such as this is extremely vital, because it allows for you to be able to designate whom it is that you wish to make decisions on your behalf, but also to actually express what those issues are, what those wishes are. And, you know, Deanna will get more into later on how the hierarchy would work if in the event such a document was not in place, but it does not simply work that just due to a relationship that you have with someone that it would provide you with just the ability to be able to make decisions on behalf of that person. And that's why it is extremely important that we do have such a document in place to be able to make those decisions on our behalf.
So Tommy, one of the questions I know that we get often is, why do I need to have a successor agent? So can you just give us an example of why somebody would want a successor agent? Because I know in some circumstances, there's not a whole pool of people to choose from, and it's hard to think of a successor, but I know you and I both find great importance in having some kind of succession plan.
Yeah, and that's actually a great question. I'm glad you brought it up. So the reason being is that the whole point of being able to designate someone is that we know this person has our best interest. Obviously, that's the reason why we are selecting them. If we do not have a successor appointed, that is going to fall by default to somebody that may not exactly know our plan the way that we wish it, or have to resort to some other means of enacting or having somebody step into that position to be able to make those decisions. So really, it helps to make the process easier and try to prevent headache and hardship down the line if in the event the primary agent is no longer available to serve in his or her capacity.
Or, I mean, you and I have both seen it, whether they may not be able to, or they may not want to. I've had those very few cases, but they exist, where somebody was named and they had stuff going on in their own life at the time, and they said, I'm sorry, I can't step in. I can't be that person anymore.
That's actually a very great point that has occurred to me as well. And also just due to the stress of the situation and how speaking about it in the abstract, especially during a planning meeting and having a conversation with a friend or a family loved one, you saying, I'm going to have you designated as this person. And at that point, there's really no imminency to that, right? So you don't really understand the weight that could have on the person until they're in that situation, until they're facing that situation and they're put in that position where now they have to make decisions, and it's something that they find that they are not able or capable of doing in that time. So that's a great point.
Right. So now you've told us that basically the healthcare proxy is naming people to make healthcare decisions for you. And the big question of the day is, well, then what is a living will? So can you share that with us?
Yes, so if we move on to the next slide, the living will, and usually we as a firm like to have this done in two separate documents, which I will go into as to the reasoning why. But the living will itself is essentially the guideline to that agent to express what it is your wishes are. Now, yes, they do go over some very specific situations, as you can see, the instruction as to whether to withdraw or withhold any extraordinary life-sustaining treatments. What are those triggering events? And it also allows you to cater them towards your own personal or religious beliefs. It's not just a one-size-fits-all. None of these documents are, which is the beautiful thing. That's why we call them advanced directives. It's something that we take in advance. We take that action prior to anything happening that we foresee a situation that could arise, and we hope that it never does. But if in the event it were to, our wishes are always going to be respected. And now we always think of it a lot of the times when we're doing planning is, how is this going to affect me? How are my wishes going to be carried out? But as much as it provides that peace of mind for you to know that your wishes are being fulfilled, it also is going to help those who are going to ultimately be in charge of making those decisions. And I'm talking your family, your loved ones, your friends, whomever it is that you designate as an agent. They're going to have that responsibility. And as you know, and Deanna, I'm sure you can, I know you can corroborate this, you a lot of the times run into serious arguments and issues that fall within these family members, that they may not all have the same point of view.
Right.
But having this document and having that put on paper for everyone to see that, no, this is what I wanted. This is what I want in a certain situation. It does help try and prevent those situations that could arise where not only is there argument and fighting, but sometimes that could really lead to some severe fallout, just even among family members. And it's happened. Trust us, it does happen.
I mean, honestly, Tommy, if people remember back, and now I'm dating myself, because it feels like yesterday, but it was probably a good 10 or 15 years ago that there was newsworthy. Terry Schiavo was comatose in the state of Florida in the hospital, and her husband and her parents were on opposite sides of the argument and fighting over whether or not they should take her off life support. And it all came down to her living will.
That's exactly right. That's a very noteworthy case when it comes to this. So that's why all of these documents are so important. We don't know what may come about tomorrow or even later on today. So it's really vital to plan for it ahead of time. And circling back to what I had mentioned when I first started mentioning the living wills, is the reason why we have these typically in two separate documents is that this document is really more a personal document. This is something that you would review with the person whom you're designated as the agent. So if you want to think of it as two separate things, the living will kind of is your guideline. This is what I want. These are my wishes. This is how I would want it to play out. And then the healthcare proxy is what gives them the authority to act. But realistically, it's you want that agent to understand you and know what it is that you want, because every situation can differ. And so if this living will was incorporated and tied into the healthcare proxy as a single document and was given to the doctor or at the hospital, and they see what's written there, it's likely they're just going to follow the letter of what's written there. But we know all that scenarios are different. So by really having that conversation with your agent and taking that time to go through what it is that you have in your living will, it allows them the clarity and the guidance to be able to make a decision that ultimately is something that you would have wanted in that scenario, and not leaving it to the hands of somebody else. And so
I think
now
actually you could go to the next slide.
Yeah, I was just
because
gonna
that
say,
expands on the extraordinary life support.
right. And so the extraordinary life support and the way that it is here is that New York will always presume that you want it unless it's stated otherwise in what is called clear and convincing evidence. And this particular document that we're discussing, the way it is drafted, meets that statutory requirement. And again, it does provide the instructions to the agent as to whether or not they would want any extraordinary life-sustaining treatment. So we can also keep going to the next slide because.
Okay. So who makes so now Tommy has laid out a good map for you as to the importance of these documents. And, you know, like Ashley said, I'm doing this for 20 years and I can tell you in 20 years, not everybody has these documents. So what happens if we don't have the documents in place? How do decisions get made in a health world? So healthcare decisions can be limited or compromised if you haven't put these documents in place, because there's certain things that you can do, but there's limitations to what you can do. Without the right documents, you have a loss of assets and personal dignity in some respects, especially if it gets to a guardianship. No one has a legal right to make decisions for you unless you have these documents in place. And if the case gets to be so complicated in what needs to be done and who's fighting over the decision, then we're in court at a guardianship proceeding where a judge is going to ultimately decide who's doing what. So before we get to the guardianship, there are some, there is law out there that has some guideline as to who can do what for us. And that would fall under the Family Healthcare Decisions Act. It was signed by the governor back in March of 2010. And it allows for healthcare surrogates to make healthcare decisions, including end-of-life decisions, if the patient lacks the ability to make those decisions and there are no documents in place and they're in a hospital or on hospice. So those are very specific guidelines. You know, if they're not in a hospital or on hospice, then you can't make those decisions for them. They still have the ability to make it for themselves, or we end up in court. And so we want to make sure that we understand who the surrogate is, because some people would be a little surprised. Obviously, if there was a guardianship, the guardian is primary. Even if it's not a husband or a wife, the guardian would be first. If a guardianship was not done, then it is a spouse if they're not legally separated, or if they're recognized as a domestic partner. Following that is a son or daughter. Now, this is where it gets ugly, and why I always encourage people walking in the door, meeting with me, to make sure they have these documents in place, because it doesn't say son or daughter in age order. It says son or daughter across the board, all of your children. And so if you're like my boss, Vincent, who's one of 8, that's 8 different personalities and 8 different decisions on what mom or dad think, what they think mom or dad wants. And that can result in a lot of arguing about what goes on. And then the more intense the arguing gets, the more likely we end up in a guardianship. Beyond the son or daughter, it's a parent, which in some cases you have to be concerned that if the parent is still surviving, what is their capacity and how are they managing things? Then you have brothers and sisters, which is similar in concept to what's going on with son and daughter, because again, brothers and sisters could be multiple siblings. My husband's an only child, so if he had issues and didn't have somebody named, he doesn't have a sibling that could step in and make this decision. We have to hope that a close friend is going to step in and take that responsibility. So it gets very messy and it can get incredibly complicated, especially if the people that meet this surrogate hierarchy are not seeing eye to eye about what your wishes are and what you want. Okay, Ashley. So if it gets so crazy that we can't get to that point, then we're looking at a guardianship. So Tommy, can you tell us a little bit about what guardianships involve?
Yes, so the guardianship is something that is enacted through a court proceeding. So as you can imagine, that means it's definitely not something that is easy to accomplish. But what the guardianship does is it allows that person to step into the shoes of the person, of the incapacitated person. So it is a safe measure to know that if in the event there is ever any type of fallout, or let's say we do get to a situation where we're on the same level, there's brothers and sisters, and now they're fighting and they can't make a decision, it goes to a guardianship, and that whomever is appointed as guardian will then be able to make basically all decisions for this person, whether it's a routine major medical decision, living arrangements, education, financial decisions, estate planning decisions to protect government benefits, all sorts of things. However, the key thing to note is that the guardian may end up being someone who is not related to the incapacitated person whatsoever. That doesn't necessarily mean that it's going to be a family member or a friend. It could be a complete stranger. And now you're entrusting somebody. Obviously, they have a duty to the court and they're going to act in that person's best interest. But now you're really removing it from the confines of this person and maybe what they truly wanted. And this should always be treated as a last and worst case scenario. So that's why we always urge you to make sure that those documents are in place, because this is something that you want to avoid. It is extremely invasive and it is not an easy process. It's a very lengthy process. It's costly. So yes, while it does provide for the decisions to be made ultimately, it is not something that someone would or should want to resort to.
Okay, so Tommy, this is what you and I hear all the time as our excuse for not, as the excuse for not doing these documents. We're married. I don't need this stuff. My spouse can make these decisions for me. So where do we land in that scenario when we get to a guardianship?
Well, we did have a case where it was exactly that. It was a husband and wife, and they were split on their decisions on whether or not they wanted to have this specific paperwork in place. And the wife ultimately decided that she didn't want it, and so husband followed suit. Subsequent to that, what happened is the wife had developed a polyp in her nose, and it was really causing her discomfort, and she struggled sleeping. And what ended up happening is they went to the doctor to try and have it removed, and during the process, she actually suffered from a severe and massive stroke that she essentially could not recover, and she was placed into a nursing home. And now, while she's in the nursing home, the husband had to now go and seek to be appointed as a guardian. And it's heartbreaking, really, because this person is sitting there and he's, one, you have the thought of it all could have been prevented, but really for him, it's that he wanted to be by his wife's side. And at the end of the day, when he was in court, he's like, there's only 2 days that I wasn't able to be by my wife's side. And one of them was a medical reason because of not feeling well, but the other one was because he had to go through the motions of going to court. And he just couldn't believe that he was not able to be with her simply for the fact that he needed to go to advocate to be the person to designate as to be appointed her guardian. And it's just something that could have been avoided. And it's just, and it's really, it's very sad, extremely sad.
I think that we see more husband and wife scenarios than people would realize. It is very common for that scenario to play out because we do have this concept that we're married and we could do everything for each other. And remember, I told you at the beginning that if you're not in a hospital or on hospice, the Family Health Act doesn't come into play. And so we were in a guardianship, obviously not just for the purpose in that scenario. We were in court not just for the purpose of medical decision making. We also needed the husband to be appointed guardian for financial reasons. But it was not, I mean, there wasn't a dry eye in the place when the guy started crying. And it could have been avoided at significantly less expense and less of a anxiety driven moment, because the husband would never had to be exposed to months of paperwork, getting the court to even hear his case, and then to have to be there. So, and Tommy and I have tons of examples of this same thing in all different situations. You know, and I've even seen those guardianship scenarios where, again, the kids are fighting and it gets messy and a stranger gets appointed. So this is the last resort and not the priority. You're listening into this webinar because you understand that there's a need to do something. And so the caution here is don't procrastinate, just do it. And so let's move on, because I know that we've had some questions in advance that were specifically asking about DNRs and MULSs and how those play into effect here. So a DNR is a do not resuscitate order. It's written by a doctor. It's often done by your doctor, especially if somebody is a resident of a nursing home. They often have those updated every 6 months. And it's basically just that. It's a do not resuscitate order. It doesn't go into any more specifics. It doesn't designate any one specific person to call. It's a conversation with the person who the doctor is sitting with. They have a conversation about their wishes and desires, similar to what we're discussing. And then the doctor's the one who signs off saying that, one, they're capable of understanding the circumstance in the conversation, and two, that they've expressed a desire to not have any life-sustaining treatments. The MULST is the one that we get the most questions on, and I strongly encourage people to do this also with their doctors. It is signed by a doctor. It is a little bit more comprehensive than a DNR, because the DNR is specifically talking about not resuscitating, but a MULST goes into more of the treatment guidelines. It is, for those who haven't seen it, it is an obnoxiously bright pink, fluorescent pink, 4-page document. And I have often encouraged, I have clients who have made it very clear they don't want to be resuscitated. There's always this concern that if something happens in the house and someone calls 911, 911 is going to do something. And so I often encourage that if you're going to do this, which you should with your doctors, have it someplace in the house, like on the refrigerator, so that when 911 is called and they come in to assess the situation, if it's a grave situation, the family member or even the EMTs can see the form is there and not do anything extreme that you're not going to be happy with. So the form itself does have a section to start off with that talks about cardiopulmonary resuscitation and do not attempt resuscitation. And there's a checkbox for that. The doctor signs off on things. There's also a section there that they want to know whether or not you have a healthcare proxy and a living will. They do ask about organ donations also. And then they get more specific, where they start asking about treatment guidelines and whether it's comfort measures only. Is there limited intervention? Is there no intervention at all? They go specifically into questions about intubation, whether or not you want to be intubated. If you do, for how long? If you don't want to be intubated, do you want some non-invasive form of like oxygen on a BiPAP machine or something like that? Do you want a feeding tube? Do you want a feeding tube for a small duration of time or not at all? Do you want IV treatments? Understanding that fluids can keep you alive longer than if you didn't have that kind of stuff. And so you want to definitely understand if you want it, how long do you want it, and whether or not you would like to be treated with antibiotics. And if so, anything specific there. It is signed off by the doctor. You review it on a regular basis. There's a section there where you sign off saying you reviewed it, the doctor signs off. And every time you go to the doctor, there's a checkbox to sign again to say we haven't changed anything. This is what we're changing. And it's a great form to use to supplement what we're suggesting. It doesn't take the place of the healthcare proxy because it doesn't name agents that can make decisions for you, but it does supplement a living will because it is being very specific on what can be done. Like, for example, our living will, oftentimes, unless we've changed it for religious purposes for someone, oftentimes says that If two doctors are telling the agents under a healthcare proxy that you do not want any extreme circumstances if you're in a permanent vegetative state, terminally ill, or not going to live a meaningful life, then you just want pain management and comfort care, the most will supplement that language by letting the agent on the healthcare proxy know, well, we don't want extreme measures, but this is how we're defining that extreme. So it's always good to have that. So Tommy, how can you protect yourself?
So in order to protect yourself, it really is vital to make sure that you have a plan and that you have all of your healthcare decisions and plans in order and ahead of time. So that's, again, we call it advanced directives, and it's because these are things that should be done in advance and in anticipation. So this will allow you to make sure you can control your own decisions, control who it is you want to be making the decisions for you. And it is important to keep in mind that just because you do this today, it does not mean you cannot change them. Things do change. People change, even your beliefs change. And so it is important that at least today you have something that is reflective of your wishes now. And having that peace of mind of knowing that if in the event things were to change and you wanted to make that change, you are able to. And obviously our firm is specialized and is equipped to handle any of those needs for you, and be more than happy to discuss them in further detail for your specific situation.
Okay, so let me sum up for you, and then we'll certainly dive into questions. I see about 6 questions, and I absolutely love that people are engaging. It, you know, when you're sitting on a webinar like this and we don't get to see people's faces and know whether or not we're making a connection, it's nice to see questions because it makes it feel like you're at least listening to some of what we're saying. So the difference between a healthcare proxy and a living will is essentially that the healthcare proxy is the document in which the people, you're naming the people who are going to make the decisions. And the living will is the document that you're giving those people guidance on what decisions they should make. And so that's the difference between the two of them. They work hand in hand with one another, and the MOLST and the DNR documents supplement the living will to give that added guidance as to what you want. So if you don't have these documents in place, then there's a pecking order for who's allowed to make the decisions, where it's, if you've been through a guardianship, it's a guardianship, otherwise it's a spouse, then children, then parents, then siblings, and then a close friend. And the best way to protect yourself is to have everything in place and make sure that you're very clear about what you want, and that if your mindset about what you want changes over time, you change it. None of these documents are set in stone. Everything is changeable, because we definitely want to make sure that it's the most updated and it's accomplishing all the goals that you have. So Ashley, I know that you have, you're going to help us along with the questions.
Sure, Deanna, would you like me to read them aloud?
Sure.
That's way. Okay. Regarding spouses and guardianship, does this come into play if there is a conflict in who will care for the person?
It could. It definitely could. So it gets complicated when you start to talk in those terms, because guardianship, it's not one of those things where just anyone can walk into court and say, I want to be the guardian, or I want to start a proceeding. There is a guideline for who has the right to petition the court for that proceeding. But when there is a conflict over who's going to be in charge, it often does get there.
Okay. Does a MOLST legally carry the same weight as a living will?
I would argue that it does, because it does have specifics about what somebody wants. It is signed by a doctor, so it's not like you just signed it with a friend. It's supervised by a professional. So I would argue that yes, it has the same weight. It's certainly giving very specific instructions about what somebody wants.
What specific wording is needed to allow agent to decide about disconnecting from machines to withdraw or withhold extraordinary life-sustaining?
So the withdrawal or withholding extraordinary life sustaining treatment would be encompassed in your do not resuscitate language. And so, you could go on the Department of Health website and pull out the language that they are looking for with regard to that. But it would follow the guidelines of the do not resuscitate orders.
What is the difference between resuscitate versus extraordinary life-sustaining treatment?
So the extraordinary life sustaining treatment are things like heart pumps, respirators. So respirators we're mostly all familiar with. A heart pump is a machine that is similar to a respirator, but they attach it to your heart to get your heart to pump. So hoping that it'll at some point take over and pump for itself, similar to the respirator, hoping your lungs will take over. So those are extraordinary life-sustaining treatments where resuscitation is basically breathing for you. And all of them in some form work in conjunction with one another.
And Scott, I'm glad that you were able to make it to the webinar. We had emailed before this, and he had sent this question in. Which document has priority, the MOLST or living will?
They're both so very similar. I would say that in some circumstances, because the MOLST is much more specific, or can be, you don't have to answer every question on the MOLST, but likely the MOLST is much more specific. And if it has more detail, then I would take that information because it gets more detailed, where some living wills could be general. But I've also seen attorneys that write living wills that are just as detailed as a MOLST. And I would say, it's a legal document in both forms. They carry about the same weight. I don't think one takes certain priority over the other. If you're asking this question because you're concerned that somebody is, they're different, the way they filled them out, they're different. I think that what ends up happening is you have to look to see which one was signed most recent, because that's an indication that that's their wishes, their most recent wishes.
So much seems geared toward those who are DNR inclined. What about those who wish to fight on and use every available option until the last breath?
Every one of these documents, I'm sorry, I cut you off because so the rest of that question was, what about those who wish to fight on and use every available option until the last breath? Is that the most, or is that specified in the living will or via healthcare proxy? So the healthcare proxy, remember, is just somebody being appointed as the agent to make the medical decisions for you. Both the MOLST and the living will can reflect that you want everything. And Tommy and I could tell you that, I have some, in 20 years, I will say somewhere between 90 and 95% of my clientele have said, if I can't live a meaningful life, I don't want the extremes. But then I've had people say, deviate from that a little. I've had some who are devout Catholics say, I absolutely want food and water as tolerated, and are willing even to do IV treatments because that's like getting water. They want the nourishment. And the document gets changed to reflect that. I have had people who want everything and the document gets changed to reflect that. The reason why we talk in terms of stopping things is because if there are no documents in place, the understanding is that doctors are going to do you want everything and doctors are going to do everything. So the reason why we don't make that the focal point of the discussion is because we already know the doctors are going to do everything for you. Most people, the fight that they have is when they want to eliminate certain things and they don't want certain things done. But certainly these documents can reflect that you want all these treatments. Like the MOLST itself, I was reading you the form The MOLST itself has checkboxes where you check off, yes, I want that. Yes, I absolutely want you to do that. And you could write in on sections some things that you want. So you definitely have an opportunity to say, give me everything.
All right, next on the list, what is the difference between a durable medical power of attorney and a healthcare proxy?
Okay, so Tommy, I'm going to give you this one, and I don't know of a durable medical power of attorney, but I do know of a durable power of attorney. Although I think that in some states they refer to the healthcare proxy as a durable healthcare, medical power of attorney. So it may just be state
Semantics,
terminology.
right? Yeah, exactly. So in terms of the power of attorney, if it's specifically that, as Deanna mentioned earlier, that's really more for financial decisions, and the word durable there just means that it's in effect even after you become incapacitated, after the fact. And if it's a durable medical power of attorney and it's something that's similar to the healthcare proxy, as Deanna was just saying, then it could simply just be a matter of semantics.
Right. I mean, also, so that you understand, in New York, our durable form is generally our durable power of attorney, which is a financial document. And it's you appointing somebody to handle financial decision-making for you. So in New York, when we talk about durable power of attorney, we're talking about a financial document, and we refer to our healthcare proxy, our medical form, as our healthcare proxy.
What if your living will and your MOLST differ?
Like I said before, if they differ, I would probably look to see which one was done most recently, because that's usually an indication that your wishes changed, and they would take the most recent of the two.
Sorry, Deanna, I missed you saying that. I apologize. Next question is still unclear about wording about disconnecting, for example, the heart pump beyond necessity.
I mean, I don't have specific wording that I could rattle off the top of my head. That would have to be something that we would have to provide at a later date.
Okay. And finally, Miss Cheryl Moore. This question may have been asked, but I was wondering if I need to get the healthcare proxy, DNR documents, et cetera, from your office. Where do I go online and find them on the New York State website?
Okay.
Good question.
So Cheryl, that's great. I love that question. So I'm an attorney, and so I'm always going to encourage you to sit with an attorney and complete these documents, because, for example, the healthcare proxy, and I'm going to give you a real example and be honest. The healthcare proxy that is on the New York State Department of Health website, I don't know why it hasn't been updated in all these years, because the HIPAA laws, those private medical information laws, are in effect for almost 20 years now. But when you pull up the healthcare proxy on the Department of Health website, it doesn't have any language in there authorizing your agents to get private medical information. And so in that extreme circumstance where you're dealing with a doctor who's had someone sue them for giving out information without the authority to, I don't want you to be in the middle of an emergency and you can't get all the information you need. Because generally speaking, with that Family Act and that hierarchy, they give you information specific to the emergency at hand, and not necessarily the outer, the other things that are going on. So for example, and those of you who've heard me before know that I often use my mom as an example. She's a nurse. Nurses are the worst patients ever. And so she commonly, to save us the anxiety and stress, having had a father who was sick most of my life, she doesn't want my sisters and I to worry about her. So she often will have a symptom, go and deal with it, and then after the fact, tell us, I had this going on, I went and had this test. So if something happened to her and I didn't have the ability to get the private medical information, I might not know everything going on with her to be able to make the decision she wants based on what the circumstances are. And so I always encourage you to have a professional do them instead of just downloading forms yourself, because there's so many nuances. The Healthcare Proxy on the Department of Health website, I do not believe talks about organ donation, and it doesn't talk about HIPAA. More people are comfortable explaining on a healthcare proxy that they would like to donate an organ, rather than going and marking it on their license, because there's this perception out there, and it is, you know, for whatever reason it exists, but I've been to lectures that dispel that myth. But there's this perception that because on your license they put a heart on your license, that if you're going to donate, that when people in an emergency see that you have a heart on your license, if you're not conscious and can't speak for yourself, they're just going to stop doing everything because they want your organs. And that's not how it works. There's a whole process there for organ donation. So what a lot of people do is they use their healthcare proxy as a means to be willing to donate organs, but it's the agent who has to authorize it. And then it gives the agent the ability to assess the situation and say, no, they still need those organs because they're going to come out of this, versus no, let's do nothing and take them, in that myth that people have. So I would certainly encourage you to speak to a professional like ourselves and have these documents done, because there's so much more of a conversation that's had than just printing a form and filling it out.
Alrighty, thanks, Deanna and Tommy. I'm going to move to the next slide here. If we get another question, we'll circle back around before we close out today. So what makes Russo Law Group different? Team Russo has attorneys like Deanna and Tommy who will use their experience and knowledge to provide solutions to your problems or help you avoid problems in the future. I'm going to put my webcam on here. We have over 35 years of planning experience to qualify clients for Medicaid. We truly care about our clients. We've served over 18,000 families across Long Island in 3 convenient office locations: Garden City, Lido Beach, and Islandia. We will make home visits if necessary and arrange out-of-office document signings. We are also available for virtual meetings and consultations. We are very strong with handling crisis situations and have a robust trust and estate administration department. We have 5 partners, 5 associates, over 20 administrative and support staff. So we're a big firm, and we are also ranked as a best law firm by the US News. So now, my fun part is that for everyone joining us live today, I am excited to offer you all an exclusive discount on your estate planning meeting. So let me set expectations with a very simplified summary. During the meeting, you'll sit down with an experienced estate and elder law planning attorney like Deanna or Tommy. The attorney will first review your personal and financial information, ask you questions to make sure they fully understand what your objectives are, review any existing legal documents, and then develop an action plan that's tailored specifically to your needs and your desires. So the fee is typically $475, but we are offering this to you for just $300 for up to 90 minutes. So don't wait, give us a call and book your planning meeting. The coupon does have some restrictions. It's only being offered to those of you on this webinar right now. So you have to be live, not the recording later, as much as we appreciate everybody listening later on. And also you need to call and schedule your meeting before September 30th. So please keep an eye out for your coupon to be emailed along with today's recording. You should bring the coupon with you to your planning meeting. Just checking back at questions. Looks like Cheryl made a comment back. Sounds like her mom. She's a retired nurse and appreciates you clarifying. Any final words of wisdom before I close this out?
No, I just want to thank everybody for their time, and I wish I could see your faces, and I hope you all have a great day.
Thank you all.
Awesome. Thank you all for hanging in there with me for my bumpy start. We appreciate all of you for joining us. Please leave your feedback in the post-webinar survey. That will appear on your screen momentarily. So until next time, be well and stay safe.
Thank you.
Take care.
Bye.